Good morning, ladies and gentlemen. CDH is extremely pleased to be hosting this webinar on a foreigner's right to work in South Africa. Now, this is a topic which continues to garner much interest because of the proposed overhaul of the existing system and substantial amendments to the immigration regulations, which have been much spoken about over the last couple of months. So let me start off this morning by giving away my age. When I studied immigration law, and I'm going to think Andreas as well, it was under the repealed Aliens Control Act of 1991. And when I heard about the Aliens Control Act as a student with no gray hair, it really got my attention because the study of law I thought was about to become very exciting because I was an admirer at the time of the sci-fi film produced by Steven Spielberg in the 1980s called E.T. Now that's a classic for all of the millennials who are on the webinar this morning who've never heard about it. An absolute classic. You've got to watch E.T., but it's actually got nothing to do with aliens when it came to the Aliens Control Act. Then back to university, we came to realize that the Aliens Control Act regulated foreigners in South Africa and how they were to be dealt with under legislation at that point in time. So the Aliens Control Act then gave away in 2002 to the current Immigration Act, which we've now all become very familiar with. And as it was early in the 2000s when I was a student, was that immigration law is touched by constitutional law principles, and we leverage constitutional law rights very often to advance immigration rights of individuals through the courts, unfortunately, more often than not these days. So this morning we intend to discuss a general overview of the Immigration Act. Then we intend time that we've discussed the visa application process and the practical consequences of the backlog at the Department of Home Affairs, which we all become very familiar with, unfortunately. And then the impending amendments to the immigration regulations with a particular focus on the introduction of the much anticipated remote working visa, or what's colloquially been called the nomad visa. And its intention is to allow foreigners to work remotely from South Africa, and then to also discuss a new scheme called the Trusted Employer Scheme. And for those that practice employment law, this is a different kind of TES, not a labor broker TES. The employer scheme aims to provide a more flexible and expeditious pathway for foreigners to obtain work visas in South Africa. To get into this discussion, I'm joined this morning by Terren York, who's a senior associate in our immigration and employment law practice, and a special and a very warm welcome to our guest speaker, Andreas Krenzel. Andreas is a qualified attorney himself, and he's also a registered immigration practitioner, and he's the managing director of IBN Immigration Solutions, which is one of the largest immigration services consulting firms in Africa. So we really excited to have Andreas join us this morning. Andreas has also co-written 2 books on corporate immigration in Africa and is a contributing expert on the African law portal called AfriWise. So without further ado, perhaps if we can get into some introductory remarks with regards to the concepts of immigration law. Perhaps, Terren, if we can ask you to kick off the discussion, just with a general overview of the Immigration Act and the right to work in South Africa.
Good morning, everyone, and thank you, Imran, for that introduction. So the Immigration Act is the piece of legislation that governs the admission of persons into South Africa, their residence in and right to work in South Africa, as well as their departure from South Africa. Of particular importance in the Immigration Act for foreigners who intend to work in South Africa is the definition of work in the Immigration Act. The definition of work is defined as a foreigner conducting any activity normally associated with the running of a specific business, or being employed, or conducting activities consistent with being employed or consistent with the profession of the specific person, with or without a remuneration or reward within South Africa. As you can see, the definition of work is quite broad and does not distinguish between foreigners who are employed by South African employers or foreigners who are employed by foreign employers. Practically speaking, what this means is that any foreigner who intends to work in South Africa needs a work visa in order to do so. When dealing with the foreign nationals or foreigners' right to work in South Africa, the Immigration Act outlines the different work visas that foreigners may apply for, and it goes a step further by authorizing the Director General of the Department of Home Affairs to impose certain terms and conditions on a foreigner's right to work in South Africa. These conditions may include a limitation on a foreigner's employer or a limitation on the position in which a foreigner may be employed in. As a practical example of this, if a foreigner has been issued with a work visa that specifically states that they're only allowed to work as a human resources manager for Cliff Decker Hofmeyr, for example, they're not allowed to use that work visa to work as a receptionist at CDH. Similarly, that same foreigner cannot use that work visa to work as a HR manager for another employer, such as Clicks, for example. So they are limited to the specific conditions imposed on their work visas while they are working in South Africa. If a foreigner would like to apply for an alternative position or work for an alternative employer, they then required to apply for a change of their visa conditions. And the Immigration Act does make provision for this process as well. And in the context of that example is particularly relevant when you consider an employee's natural progression within an organization, such as through promotions. So it's very often that when an employee is initially employed, an employer is employing them based on the conditions of their visa, but a couple of years later, they've changed roles within the organization, but their work visa conditions haven't changed along with them. So that's also an important aspect to consider when dealing with the foreigner's right to work in South Africa.
Yeah, and I think Taryn, that's a valid or an interesting point, because it quite often happens in practice that the restriction is in relation to position A, and a person either wants to move to a new employer because there's another opportunity, but can't do so because of the restriction, or alternatively on the promotion. But it's an interesting point. But perhaps let's just pivot to Andreas. Andreas, just generally the different work visa categories that are available. Just talk us through those.
Okay, so in essence, there are 4, and I will mention maybe a 5th one. So we have the short-term work visa. It's called a Section 11.2. I mean, the section is visitor visa. 11 is the visitor visa, and that's a visitor visa with an endorsement to work. That's valid for 90 days. You apply overseas at the South African mission of your passport or residence, and it can be extended once by another 90 days from within South Africa within the same calendar year. That's the general principle. So for big projects, longer running projects, it's a bit of a difficult situation. You'd have to rotate potentially staff, and also practically the extension of the 11.2 locally in South Africa sometimes poses some problems. Yeah. So that's the short-term work visa, and then obviously the long-term work visas, we have really 3. That is, we want to start with the intra-company transfer. It's the critical skills work visa, as well as the general work visa. And yeah, I think these are the 3. And then obviously one must not forget that legally you can work on a study visa up to 20 hours a week, and also refugees are legally allowed to work in South Africa. Not work visas, Imran, but yes, obviously allowed to work.
Yeah, so let's just discuss the refugee visas or permits. They've in our experience, between Taryn and myself, we've seen these somewhat open to abuse. I don't know what's your experience around it.
Yeah, so yes, I mean, most of our clients, they don't employ the refugees, so yeah, we traditionally not super experienced. So what we try to sometimes do is to verify them with MIE, so you can verify them obviously, and also you can ask stories, you know, where they came in, which refugee center they applied for, because you can sometimes pick up inconsistencies, because remember, usually where they register, that's where they have to renew. And then there was obviously an exception because Home Affairs or refugee center in Cape Town for years did not exist or was closed. So you need to probably inquire a little bit more about it. And as I said, MIE, which is a private organization, does verify these permits. However, I would not always say that MIE gets 100% the right results. So one needs to be a bit careful there as well.
Yeah. And well, let's perhaps talk about the critical skills visa. Taryn, perhaps you can come in on the CSVs. Any new developments around that? I know there has been some discussions about critical skills over the last couple of months.
So I think what posed or what informed all the discussions in the last couple of months is the proposed second amendment to the immigration regulations. So when the proposed regulations were published, there was a lot of misunderstanding of what that meant for the critical skills visas. And a lot of people interpreted the amendments as meaning that the critical skills visa category would no longer exist and that this visa option would no longer be available for foreigners working in South Africa.
And yes, sorry, I interrupted you.
No worries. So that position has now recently been clarified by the Minister of Home Affairs, who said that there is certainly no intention to get away with to do away with the critical skills visa, and in his opinion, it is one of the easiest visas to obtain in South Africa.
Yeah. Well, I'm going to take Andreas' smile to be easiest with lots of complication. So Andreas, I'm putting words into your mouth. Let's discuss it, because we come from different angles on it, and that's our experience as well. Just talk to us about your experience with critical skills.
Yeah, so I mean, Taryn, I just wanted to say it's always nice how the press and the minister says that there was no intention. Okay, if they would just get the wording of the draft regulations correctly and not write section 19, but maybe, with subsection, then we wouldn't have that problem. But anyway, I'm glad the minister stipulated that. Now, critical skills in practice obviously has a challenge, right? And that's the professional bodies. So SAQA used to be, before COVID, very reliable. That took 30 to 40 days, great organization, 120 staff members. Then came COVID. I visited SAQA after COVID and said, why are you taking 6 months now suddenly to issue certificates where it took you a month reliably for years? And they told me they were reduced to 30. And then they were built up, right? So let's be honest, we can complain a lot, but with that kind of minimized staff, it's a problem. Now SAQA is back to 3 months, so they're getting there. I mean, COVID is also a couple of years ago, but that's challenge number one. So SAQA is compulsory, and obviously that takes already 3 months or 2 months. If you studied in South Africa, obviously in your highest degree South African, you don't need SAQA. But the next challenge is the professional body, and depending in which category you fall, it depends which professional body needs to recommend your skills. And if you're an engineer, and we all know that from the 20 professions, there's a lot of engineering professions on there, then it can take a very, very long time. If you're in IT, it's great, it goes quick. So it depends very much on the professional body. And then I think so that's challenge number 2. Challenge number 3 is that Home Affairs introduced with the new critical skills list, I think, when was it, August 2022, 23? Sorry. They introduced for the corporate general manager and for all the business dedication positions, they introduced the minimum size of the company, which is usually 50 employees and plus, which is not a problem for well-established South African companies. But a lot of overseas investors or investment, they start with a small company with 5, 10, and then they scale, but they can't get anybody in on corporate general manager or other positions. And that I think these are the 3 major challenges we see with the critical skills. The processing times, however, in South Africa at the moment are super fast. They're like 4 weeks. They're really hammering them out. So that's the good thing.
So on foreign businesses, I mean, and we know the government position on FDI and all of that. So the legislation doesn't meet the practicality in relation to a foreign entity that wants to set up. But do you think that the intention is to almost compel a foreigner to employ a local at the top position, or do you think it's just, it's something that just happened in? I know I'm putting you on the spot.
I think. I think in the heads of our politicians, although I certainly can't speak for everybody, but I do think that is in their heads, yes. But let's be honest, that's not realistic. I mean, if there are foreign companies who want that C-levels, or at least one or two positions, obviously be foreigners, especially when they start. Once they mature and you have Employment Equity Act and you have local talent and you bring them through the ranks, then usually the experts are too expensive. They're being phased out, and you will see this with all the established South African businesses. They hardly employ foreigners, right? But especially when you want to attract foreign direct investment, typically to the startup phase, the scaling phase, usually you send somebody who's experienced in your system, in your customers, in your products, in your company culture, right? And not hire somebody externally.
Yeah, so I'm gonna agree with you on that, Andreas, because that's been my experience as well. So foreign companies, wherever they're based, they come in and want to place somebody at the helm of the local entity who understands the business, comes through the business, and then sets it up. And then over time, you get to the point of handing over to a South African. So the difficulty is setup and the inability to employ the foreigner, which makes FDI difficult. And hopefully in time that bottleneck kind of is identified by government and sorted out. And Terren, Andreas, I'll leave it to either of you. Perhaps you want to talk about the intercompany transfer work visa and a general work visa, just the distinction between the two.
Terren, or you want to go?
Sure, I'll jump in on that one, Andreas. So an intracompany transfer work visa effectively authorizes a foreign branch or subsidiary to transfer a foreign employee to a local branch or subsidiary in South Africa. So in our experience, this is probably more in line with one of the easier visas to apply for and to obtain because of the requirements of the visa. But I think what's important from the intracompany transfer visa is that there has to be a skills transfer plan in place in order for the foreign employee to transfer to the local skills beneficiary, and a skills beneficiary needs to be identified. So the sole purpose of that visa is for the foreign employee to transfer their skills in order to upskill a South African citizen or permanent resident.
Okay, got it. And then in relation to the general work visa, the distinction, if one can be made.
Yeah, so maybe I don't mean here. So obviously the general work visa is the last resort, right? So if you don't critical skills and you're not ICT, then you're looking at general work visa. And before the amendment years ago, the Department of Labor was not involved, and as you know now, it is involved.
Yes.
And that has led to a basically die down of this category. I mean, we used to do quite a lot of general work visas. I think we have done one in the last 7 years because the Department of Labor does not recommend. Also, their database is not fine enough. It's so wide that they always find suitable candidates, and then the companies say, well, they're not suitable even on paper. So I think the general work visa in practice was dead. And that is exactly why the minister now obviously introduces the scorecard for the general work visa and has abolished the Department of Labor recommendation or involvement for exactly that reason, so that they saw it and they have fixed it. Yeah, that's maybe to that. I think on the ICT, it's just, I think an important part is obviously that Home Affairs really sees it as a temporary assignment into the country for 4 years. They're extremely reluctant for an extension. They're extremely reluctant actually to grant permanent residence on it, and that's maybe the last comment on it. So in practice, we get a lot of questions always from clients. Hey, I had an ICT for 4 years and maybe critical skills for 2. Can I now apply for permanent residence? I'm permanently employed, right? And there's a category obviously offering this, and then Home Affairs has always rejected these permanent residence applications because they said the ICT doesn't count into the 5 years. Yes. Now I just want to share with the broader audience. Yes, they say that, but just apply still. Legally, they're totally in the wrong. And I know there have been court cases, they have been settled, they're not publicized, but they have lost several times in court. The law is clear. The ICT does not exclude counting towards the 5 years because the formulation in the law is crystal clear. So I just wanted to share that because it's often I hear these questions because obviously if you're here for longer, usually people are interested in permanent residence.
Yeah, and it's the track to permanent residence that quite often also gives rise to lots of disputes. And then let's perhaps talk about this nomads visa. Terren, let's jump into that, because that's been a big talking point for a while. So talk us through just what the concept is and where we are on it currently.
Sure. So this is currently not one of the visas provided for in the Immigration Act, but it is certainly one of the visas that a lot of people are the most interested in because of the move to global mobility and flexible working arrangements. So the regulations seek to introduce the remote working visa, and this will allow foreigners to work within South Africa remotely within South Africa for their foreign employers. The requirements of this visa aren't really clear. I know Andreas and I did try and speak about it the other day. One of them is that the foreigner needs to earn a minimum of 1 million rand a year, but it's not clear whether that 1 million rand is a gross amount or a net amount, which would then affect whether or not it's extremely accessible within South Africa. But that is certainly the intention, to allow foreigners to come work from South Africa remotely. And also one of the reasons is also just to boost tourism as well.
So, Andreas, your comparisons of this nomad visa in relation to other jurisdictions, any thoughts, any comments on that?
Yeah, I think it was a nice marketing idea, and I think it is very well intended. No, it's very well intended. I mean, I personally, pushed for 2 years that we get it, but I think in the current format, it's not very competitive. And that's number one, is the 6 months registration with the South African revenue authorities, because they did not amend the Income Tax Act and made an exclusion for a year. So to answer your question, Imran, well, international standard duration is at least a year now, with a tax exemption for 1 year, and some countries already granting 2 or 3 years remote working visas. But 1 year would be, I think, 1 year would be great. But I mean, they're not gonna register for tax. Well, they have to, but that's not that's not competitive. And the other major drawback is that the remote work visa very clearly excludes self-employed people. Now, if you know in practice, most digital workers, remote workers, are actually freelancers. So that's what I'm saying. Again, I think somebody did not really do the homework. I mean, my personal opinion is that the president put it into the speech twice, right? He wants it, and the Minister of Home Affairs didn't want it, and then they rushed it through because he got so much pressure that he had to comply, and then they didn't amend the Income Tax Act. So, and there we stand now with something which is nice from a marketing perspective, but not very practical in my opinion.
Yeah. So the tax issue, I know has been a big flag, and Terren's been trying to get some grey hairs, I think, because of that. So Terren, I mean, Andreas makes the point in relation to tax, and there was a concern that you had around it as well, is the tax liability in relation to a person on that visa. So where are we currently with this nomad visa? I know it was open to public comment for a period of time, but what's the current status on it?
So just on that tax component, also the regulations impose a specific requirement. So if you get a nomad's visa for less than 6 months, you're not then required to register with SARS. But if you get it for longer than 6 months within a 12-month period, then you have to register with SARS. And I think that's what Andreas was also speaking to. So the regulations aren't open for public comment anymore, and they were actually gazetted a day before the deadline for public comment closed. And because of that, NEDLAC raised certain issues with this, and the minister then withdrew the regulations. So the regulations currently have been withdrawn, but they will be re-gazetted. I think it will take a couple of weeks. The minister did say that the substance of the regulations will remain the same. They will maybe just work on some of the errors or misunderstandings that have been raised before they gazette them again.
Then let's perhaps just talk about the visa application process, the actual practicalities around it. Andreas, your experience. I mean, there's no secret about. Yeah, I'm going to be polite about the backlog at Home Affairs. In your experience, one reasons for the backlog, and are you seeing a clearing of backlog and just the general turnaround times from Home Affairs? Your experience around that?
So, I mean, it goes through the press a lot, and everybody likes complaining about Home Affairs. And I want to, well, I'm slightly of a different opinion. So we as South Africans, we know that Home Affairs has improved their services for civic services. If you apply for a South African passport, you get it in a very, very fast period of time, thanks to technology, right? We get there installed technology, and you're going to get that faster than in the European Union. Okay, my German passport takes 3 times longer than my South African passport. So
Andreas, sorry, can I just give you my experience, because I have to say this here. So I had to renew my passport at the end of last year, and I told Karen this. So I go off, and like 2 days later, I get an SMS to say ready for collection. I said, absolutely not. This is a scam. There's got to be a scam. But you're quite right. So talking to it, I've seen it. The turnaround time is fantastic.
I had exactly the same experience, and I reacted exactly the same. It's the wrong SMS. I know I have submitted, but it can't be ready for collection, right? Anyway, so what I want to say is, now we come to foreigners. Okay, so Home Affairs has chronologically underfunded on the foreigner side. Okay, so forever. Okay, they ask for more budget, they don't get it. There might be lots of reasons why the foreign part does not get funded like the South African part, but let's not go into that. So with that comes a technology challenge. We all know that government struggles to implement world-class IT systems because they have to use their own resources and other government entities, etc. Okay, we know that. So that's an objective challenge Home Affairs faces. The third one, I think, is obviously internal. It's management. Let's be honest, right? I don't think they have the best management systems in place, and maybe not the most motivated employees. The truth is also that they lost after COVID and before COVID, especially under the new minister, they lost a lot of high-ranking officials due to corruption allegations, right? So they have lost a lot of decision makers and had to replace them. Okay, and then the last point I want to make is that the minister then, as a result, removed the delegation of powers to sign off visas and centralized that to a few individuals. Now, you can imagine if you're having 80,000 visa applications and a few individuals can sign them off, you're causing a massive backlog. Okay.
Yeah.
So partly I want to say, well, there are very objective reasons why there is this backlog, but partly obviously they're also house-made. I mean, there's no question about that. Now, what they have done the last 2 years now, they're focusing on certain criteria, on certain categories to allocate the resources they have onto these visa categories. That is the business visa, so for investors, entrepreneurs. It is the critical skills work visa to attract highly talented individuals. And there it stops, kind of. Okay. What it means in essence is that they moved officials from other parts into these units. And also they have these corporate accounts units, which works pretty well under Mr. Mbele. Okay, so that's good. But if now what the result is, and that goes through the press, and it goes correctly through the press, is if you're a spouse of a South African or of a permanent residence holder, you wait for 2 to 3 years for your visa. And these spouses want to work, and they run their own businesses. They don't feel welcome. They can't travel. It's a nightmare, and it's well, I don't want to, it's completely wrong what they do, completely, and it's disregarding. And the minister has even said in a statement, well, the spouses can't work in South Africa, they don't contribute to the economy. I mean, that's not but it shows you the attitude, and it shows you that the cause for the backlog is a misallocation and a lack of management to take them serious, because they have rights as well. They don't just contribute to the economy. So that's why I don't want to say everything is bad, and that's why I probably gave a bit longer answer to your question.
Our experience. So everything that you say at the higher level has been our experience as well. But let's talk at a very lower level. And thank God this is not load shedding. This is just us saving money. At the lower level on adjudication, and Terran experiences quite often, and I'm sure you do in your own practice, Andreas. So the application goes in, all the documents are there. At a very junior level, somebody just doesn't read the application properly. And then you've got to file the appeal, and you've got all of those further administrative processes to go through. Now, typically what happens, and we see this quite often, is as you go through these processes, or you apply pending a new renewal of a new visa, the old one is expired. I know it's a very general question, but in your experience generally, what happens to that person? Is that person legally entitled to remain in South Africa pending those processes? Or do they need to leave the country, go outside of the country, apply for visas? I know it's a very general question, but just generally in your experience.
Terran, is that for you or for me?
That's
to me, but
no, Andreas, if you want to take it.
Okay. So the general rule is clear. If you're in South Africa and you applied in time for an extension of your visa, and your application is pending, and your first visa expires, you're legally allowed to remain in South Africa. Not to remain working in South Africa.
Yes.
Okay. So to remain in South Africa and await the outcome of your visa. Two things you're not allowed to do, or maybe even more things. But if your work visa expired and your new one is not issued yet, you're legally not allowed to work. Okay, but you can remain and await the outcome. Number two is obviously you must not travel outside South Africa exactly in the period when your visa is expired and you're waiting the outcome, because you're legally allowed to wait in South Africa, but you cannot travel outside, because then you will be declared, or you might be declared, undesirable. So that's a very, very tricky part. Now, in the last 2 or 3 years, we always had concessions because of the backlog taking care of this, but these concessions have, well, not been renewed or expired. So our default position before is again applicable. So you need to be wary that you do not exit South Africa on an expired visa, despite waiting for a new one.
Yeah, and the difficulty for a lot of individuals is the inability to work.
Yeah.
And that becomes a big problem, one for the individual, becomes a problem for their career progression, and obviously a big problem for the employer. Because when they come to us, the legal advice is generally quite easy. You may not employ this person, and now what do you do? So you sit in a precarious position, but I guess on the right case, it's got to be tested in court that if you're waiting, and especially on a matter where you should have succeeded at the very early stage, that you should be allowed to work, notwithstanding where you sit currently, because it is a very precarious position. Mm-hmm. So we've identified a number of these, let's call it troubled areas. Perhaps let's look at the trusted employer scheme. Firstly, Terran, do you want to just give us a general explanation as to what it is? And then Andreas, I know you've been quite vocal about your support of it, and you can talk to us about that thereafter. So Terran, take it away.
Sure.
Firstly, what is it, and what's the intention?
So the intention of the Trusted Employer Scheme is really to provide a flexible and expeditious pathway to foreign nationals obtaining work visas in South Africa. And the implementation of the scheme is it has already been implemented, although it forms part of the proposed regulations. And the intention is also to shift the onus on prospective employers to obtain documents on behalf of the foreigners, such as their police clearance certificates, their SAQA certificates of evaluation. So it really is to get the employer more involved in the visa application process and to take a little bit of responsibility away from the Department of Home Affairs as well. And in order to be registered with the scheme, the requirements are for the employer to have invested a minimum of R1 million within South Africa. They must have more than 100 employees, with at least 60% of them being South African citizens or permanent residents. And there must be a skills transfer plan or development program in place. And the scheme is also only applicable to employers within certain sectors as well.
Andreas, I know, I think, at least from some of my readings, is that you've been supportive and you've in fact applauded the Home Affairs in relation to its move on the TES. Just explain to us from your perspective your exuberance in relation to the TES.
Well, the exuberance, I think it's always easy to criticize Home Affairs, but I mean, you know, when positivity is true or is due, then one should give it as well.
Yes.
And for companies who are registered now with TES or in the future, it's a total game changer to attract foreign skills completely. They do not need SAQA anymore. Terran is right. They need maybe SAQA or the verification of the documents later. So the employer has to do it. But when you're applying, the foreigner applying for the work visa, you don't need SAQA anymore, and you don't need a professional body recommendation. Now, we just talked obviously about half an hour earlier. We said, what's the two biggest challenges for the critical skills? It's SAQA and it's the professional body, right? So these have been waived, and therefore you basically, if you have a letter of employment and you do some background checks, you can literally apply for a work visa. Now that is even into international standards. I don't compare to Africa. Now I'm comparing worldwide. This is world class, okay? And the reason for Home Affairs is obviously they said, okay, these employers we vetted, they are trusted. So we give them the trust that they're compliant employers. Therefore, we do not check every single document that the applicant provides, and that's why they do it faster. They're dedicated a special unit for it. They are signing agreements with the corporates where Home Affairs undertakes to process application in a certain period of time, and they're fast. I mean, I haven't read the last MOU now, it's not in the top of my head, but it was literally a week or 10 days overseas, and it was, I think, in South Africa within 2 weeks. So we're talking about super fast processing times. Now, I know we now here in the law firm, and I don't know what happens if Home Affairs breaches that agreement, but let's not talk about that now. But my point is, they have committed serious resources, serious staff, and really to make it very simple and easy for these trusted employers. The problem is obviously that the first registration period has been closed, and if you're not registered, then your competitors might have a serious advantage. So now the next big question is Home Affairs potentially opening TES again? And I think there should be a lot of public push to Home Affairs to ask, please, hey, we missed the one in November because they rushed it before Christmas in as well. And then it was like 3 weeks only. So it was really rushed. And the minister did say in one of his last speeches that they might open it in May. Now, if I hear May and I think South Africa, I don't think they will do anything in May, but maybe it's soon. I don't know. But so I think the push must be open TES again, and then the corporates need to be aware. And the criteria are, Terran said them. You need to be compliant in a certain size, etc. But it's highly important. Strategically, it's the one thing you want to look out for.
I'm with you. And do you have any insight, Andreas, in relation to what the take-up was on the first registration, or in fact the only registration?
I don't know the official numbers because they're not public, at least not to me. But I mean, we assisted about 15 corporates or 12, and I'm sure 50 or 60 have registered successfully. That's my uninformed gut feeling. So I think the uptake was great, to be honest, for such a short period of time. But we also know that large corporates, they sometimes takes months to make a decision, right?
Correct.
So that's why I'm saying here now in this audience that if you're HR, this is the one thing you need to watch out for, because it's highly competitive and gives you a strategic advantage.
Yeah. So moving away from the TES for a moment, let's get to the ZEP. Terran, just where are we currently on the ZEP? And I'm then going to ask you the difficult question: where do you see ZEPs over the next period of time? And I know there's an election coming, so it makes things even more difficult. But I'll leave it to you.
Sure. The current position with ZEP, so over the past couple of years, they have been extended on a number of occasions. The last extension was granted until the end of November 2024, but then that came with an additional allowance that's so automatically extended until end of November 2024, but then ZEP holders could then apply for new exemption permits that would be issued until the end of November 2025. So safely and securely in South Africa, allowed to reside and work here until the end of November, but they must apply to get the new exemption permit so they can work until the end of November next year. Alternatively, they need to try and apply for another mainstream working visa.
And I guess to a large extent, it kind of we've got to just wait and see what happens with ZEPs post the election and whatever happens thereafter, I guess.
Yeah.
Okay. Then let's perhaps try and pick up some of the questions from the audience. There's a question with regards to critical skills. Andreas, I'll put this to you. The comment is that the NQF levels are unrealistic in relation to critical skills. Your view on that?
I totally agree. It has I mean, the first version had more or less always NQF level, I think 5 or 6 for most of the positions, and some maybe 8. Now, I mean, 8 is the minimum, kind of, right?
Yeah.
And that's a master's degree, and so in practice, huge challenge, way too high. I totally agree with that. And if there should be lobbying from the industry, it should be exactly that. I think the NQF level is at least 2 levels too high. I mean, nobody wants NQF level 4. We all agree with that.
Yes.
But I mean, a 6, like a bachelor degree, maybe an honors, maybe, but 8 is just, it's too high, because a lot of international people, they don't have master's degree, and because the work experience doesn't count anymore, you know, you can have your business degree, which was 4 years overseas, and then, well, work 20 years, and now you don't qualify as a corporate general manager. Now, I don't think that's realistic.
Yeah, and I mean, you using this cliche. If you only have a hammer, every solution is with your hammer. And when you come and talk to lawyers and litigation lawyers, they're going to tell you, well, the solutions unfortunately lies in litigation. The difficulty that we do experience. I mean, over the years, you'd have a client that comes along and says, well, this NQF is unrealistic. So what do you do? The reality is, well, you must show why it's unrealistic, and you look at it, the facts of a particular matter. The only way you can deal with it is actually go to court. Now, you know, and in a company, as an employer, has got to make a big call. Do we really want to incur, one, the cost, the time, the effort to challenge this, to challenge the NQF registration, then get involved in potential appeals, or do we just simply say, let's forget about it and we move on? So lobbying industry, or industry lobbying government, is obviously the way to go. But in the particular, in particular matters, and there may be the right sort of case, there's got to be a challenge to say the requirement is actually arbitrary. It can never be achieved, and therefore you've got to litigate it. And you've got to get to a point, and somebody's got to be, you know, open the way to that. But perhaps we never get there. Hopefully we never get there. But there could be a lobbying from industry through the correct channels, and, you know, getting government across the line on that. Then let's talk about another question relates to the corporate work visas, and the question is for seasonal workers, corporate work visas. It's a good question. This has been a challenge, and does this form part of the point system at Home Affairs? This question arises every so often. Andreas, your
shall I take it? Yeah, it's fine. So it's a super question, because I have to think about it. So my answer is no. Because the draft regulations, they refer specifically, when they were misworded, to Section 19. Section 19 is the work visas we discussed, general work, ICT, critical skills. They all sit in Section 19. And also the minister said that the point systems aim at the general work visa. The corporate visa, and also the corporate worker visa, which is part of the corporate visa, is a different section in the Act. Therefore, I do not think that the point system is applicable to the corporate worker or seasonal worker. Yeah.
And then Terran, there's this $1 million question that always arises, and one from the audience, that whilst there's a change of condition application underway, and you see this so often, can the employee start working with the existing employer or a new employer whilst they're waiting that outcome? And I know you know this answer, but you can say it in your sleep.
Yeah, it's the answer that no one really wants to hear, unfortunately. So no, they cannot work in the new position or for the new employer until they have changed the conditions that have been imposed on their visas.
Okay, so the NCE is the what nobody wants to hear, and it goes back to the point, I guess, that we made a bit earlier, is that that individual is in no man's land, which is practically very problematic, and creates also strain for the individual, personal stress and everything that comes around it. Not to mention all the inconveniences that are associated with it for a business. Then, Andreas, Terran, I'm going to put this question to both of you. Can a person in South Africa on an intercompany transfer work permit apply for a work visa from South Africa, or do they need to go back to their home country? Andreas?
They need to go back.
Yeah.
As simple as that.
Yeah, they need to apply for the new visa from their country of origin or passport.
And Andreas, I'm not sure if your experience is similar to ours, but generally by the time these matters come to us, it's at the 11th hour. So if you're sitting on an intercompany transfer, which requires the skills transfer and all of those good things, what at least I've seen over the years is, once the permit is granted, people just move on with their lives. Up in the 11th hour, then now decisions want to be made. Well, I need to do this, I need to do that. But by then it's already very late. So we were talking about, well, what are the takeaway points? Here's another takeaway point, is that when the person comes into the country, there's got to be forward planning as to what is the intention in relation to this individual. The skills transfer to a South African is a non-negotiable, because that's the basis upon which the permit was granted in the first instance. So from an HR perspective, there's got to be a proper handover in relation to the skills transfer to make sure it occurs. Then a forward planning to say, if this person wants to apply for permanent residence in South Africa, well, let's start working on that process now, not do it a month before, because that gives rise to all of the angst. And I would say that's something for HR to look at as well. I know if that's your...
I just wanted to, I think you emphasized on 100% the right thing. So it's very important that human resources monitors the transfer of skills to the local understudy, because we had cases that when an ICT holder applies even for critical skills overseas, right, different category, they wanted to show the proof that the skills were transferred. Now, I might have a legal opinion that that's not correct if you apply for critical skills, but I mean, you can argue yourself until you're blue in your face at the missions, or you want the visa, right? So you want the visa. So what I'm saying is, and it's not completely wrong what they do. So I think it's really important that is monitored and that there's proper record keeping. And if the understudy changes, well, the understudy changes, and people resign, and that's fine. Yeah. But I think it's an often overlooked criteria. I totally agree with you. Super important.
Yeah, and then whilst we're speaking about the ICT, there's a question with regards to the white paper and the proposal that ICT be abolished. Is that correct?
Yeah. So maybe I can take that. So yeah. When they published the final draft of the white paper, I also read through it, and I mean, immigration is quite short, right? It's mostly about refugees. Yeah. So I'm reading this on immigration. I think, we abolish ICT. So obviously, it's fine. It's in the white paper. Nobody will remember. I cannot see that. I mean, the ICT is one of the cornerstones of international worldwide immigration. Lots of other countries have it. And why would we abolish this? I mean, and it's one of the categories which works. So no, I'm not too worried about that it's in the paper.
Yeah, so the white paper, our reading of it as well, is we thought there's going to be a lot in relation to massive changes that suit the interests of business and individuals coming in. But the focus has been on refugees, and I suspect in my reading of it is because of South Africa's commitments internationally to refugee law. We in fact, one of the few countries in the world that have done it. And I think that's collided with our immigration law significantly from a business perspective, that government's now found itself in quite a bit of a quandary, that you've now got all these refugee rights, which from a human rights perspective, I mean, you can't question. But it does create such significant strain in relation to residents, the right to work, and where we currently, that, you know, I guess with time, we don't have the benefit of lots of time, is that we actually need to start unteasing all of this here, so that, you know, the systems become more streamlined. We could probably talk all day, and I see the questions continuing to stream in, but perhaps we could close the discussion at this point. Terren, your closing remarks, and then Andreas will ask you likewise, just your closing remarks in relation to where we are currently on immigration law and where you think the future is likely to go, and perhaps just quick takeaways from this session for HR practitioners, HR executives, people that look after you know, these sort of affairs within a business.
Thanks, Imran. So just from a key takeaway perspective, and I think maybe just something for HR practitioners to be on the look for, is to maybe just implement systems within their organization to constantly monitor the employment and progression of foreigners within their workplace, from the time in which they're employed, when their visas expired, when they get promoted, whether they need a change of conditions, and so forth. So it's a constant monitoring process. And I know that not a lot of organizations do this on a regular basis. It's almost as though they employ the foreigner, they're on the books, and then, you know, it's just a normal employee. So I think just to implement mechanisms to monitor those systems. And I think, you know, the outlook on the remote work visa, like Andreas said, is not particularly great, but hopefully, you know, generally after implementation, a lot of these errors are raised, and there's a few other amendments. So hopefully they can be teased out a little bit more and made the dream could be realized rather than what it looks like right now. But I think from a processing time frame, we are looking at decreased timeframes for the backlog. So things are looking a little bit brighter, so not all round negative going forward.
And that's good. Andreas, on your side, closing comments?
Well, firstly, it was great fun, and thank you very much for the opportunity. But I think key takeaways, or what I really want to maybe say is I think it's really important. Well, two key messages. In my practice, I always hope that corporates think of immigration earlier than they do. Usually they think of immigration last. So there's a big project, they do the budget, and and then, oh, work visa. No, yes. The work visa, the resources should come at the beginning of the planning with the costing. So that's maybe one thing. And also obviously thinking about the long-term renewals, exactly what you said before. So that's one observation. The other one is really an encouragement to lobby, because my personal experience is that, yes, the Minister of Home Affairs and Home Affairs forget, but if you lobby through the Office of the President, if you lobby through the DTI, if you lobby through the Parliamentary Monitoring Group in the Parliament, the Working Group on Immigration, the committee, I don't know what it's exactly called, yeah. But if you go through these angles and you send clear messages, the officials are listening, they are willing to meet, so proposals do find their way in there. Okay, I mean, they do. Yes, it takes time, and is it super efficient? Yeah. No, but it does happen. And I think business in general has been very silent always. I mean, just do your part and be a little bit more, you know, more vocal. I think. Yeah, maybe that's my last remark.
Well, I think. Well, not I think. The comment is a useful comment. It's probably no different to us boring employment lawyers. So, for instance, in relation to the employment equity legislation, I mean, we actually hosted a webinar a couple of months ago, and our entire focus of the webinar was, please comment. Don't sit back, wait for the law to change, and then try and marry things into your business, make the comments, because we've actually seen that the comments have moved the needle, not all the way that you wanted it to move, but at least it's been taken into account. And there was massive changes from the draft in the employment equity legislation of last year to what we're seeing today. And your experience is very similar to ours. Is yes, engage.
Yeah.
Indicate where the problems are and where you see the opportunities. And the Nomad visa, I mean, if you read the press, you'd think, sure, this was an absolute godsend, but the tax issues were a big issue for lawyers. And we said, well, the tax is a problem. And your point in relation to Andreas, the timing, I mean, we are it's always said, an end destination. So people don't come to South Africa passing through. If somebody's going to come here, it's going to be the end destination. It's not going to be for 6 months. They're going to be here for a year. So at least, and that's what we should be catering for. So yeah, hopefully there's been some green shoots out of Home Affairs. I think there's still a long way to go, but at least things seem to be improving, and hopefully with time, the systems do improve. Hopefully that's where we go. Andreas, again, thank you very much for taking time out of your morning.
Thank you.
I really appreciate it. Terren, likewise, with your experiences on the immigration front. And yeah, we'll hopefully chat again. Have a good day. Thanks.
Thank you, everybody. Thank you very much. Bye-bye.
Bye.